Today, we will cover the top 10 mistakes DIYers make when moving their existing businesses to a new state. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. If you are even thinking about redomesticating your LLC or corporation without hiring an experienced redomestication attorney, listen carefully. What I'm about to lay out isn't gentle advice, it is a full blown call to action. Every single day, confident business owners try to save a few bucks by going it alone, and many of them end up bankrupt, audited into oblivion, facing civil charges, or watching their company dissolved while their personal assets are seized. If you think I am exaggerating, you need to do your homework. I am not. These 10 mistakes are the most common paths to total destruction in the context of moving an existing company from one state to a new state. Listen carefully, feel the fear, and then pick up the phone or the mouse or your tablet and hire an experienced attorney before you become the next statistic. Mistake number 1, believing the Secretary of State forms are sufficient on their own. Spoiler alert, they are not. Those PDF documents look official and easy. Just fill in the blanks, pay the fee, and you're done, right? No, not exactly. You are dead wrong. And that is a lot like performing brain surgery on yourself in your kitchen without anesthesia using a cleaver. Probably not the best idea. These online templates and forms are deliberately minimal. They do not include the mandatory supporting documents, including a plan of domestication or conversion, that make the transaction legally binding. As I mentioned, that would include a bespoke plan of conversion, a unanimous written consent, board meeting minutes, or shareholder resolutions adopting that plan, and precise provisions addressing the Internal Revenue Code. Got to have all of them, or you will be in dire straits indeed. Filing just the public certificate, which many states will happily allow and take your money to do, is simply step 1. Really, it's step 3 if we want to be specific, but I'm getting ahead of myself. When you perform that and you do not adopt a plan of conversion and the other documents that I mentioned, your contracts are dissolved or novated, your EIN is disestablished, and your liability shield vanishes. One lawsuit later, and creditors are coming after your house, your retirement accounts, everything. Again, no exaggeration. Don't take my word for it. You should do your own homework. You thought you saved a few bucks. Instead, you handed the plaintiff's attorneys an open checkbook to ruin you personally. If it sounds dramatic, it certainly can be. I'm working on a few of those cases right now. Unfortunately, folks ignored our advice, took matters into their own hands, and now we are performing the cleanup work. More on that in mistake number 10. But we're just on to mistake number 2, accidentally creating a massive taxable event as far as the IRS is concerned. Redomestication, when performed correctly, which is to say by an attorney who actually knows what redomestication is and how to perform it, is a tax-free reorganization under the Federal Internal Revenue Code. When you miss one step, whether that's wrong sequencing, you omit important language, or there's no continuity of interest, The IRS will recharacterize it as a complete liquidation followed by a new contribution. Boom, immediate recognition of gains, which may be capital gains, or even worse, at the ordinary income rate. We're talking 6, 7, and even 8 figures in some cases of tax that is inadvertently triggered by the DIY approach. And let's be candid, in most cases, people don't leave that kind of cash laying around the house. Penalties and interest start accruing the day it's deemed to happen in some cases. Subchapter S elections terminate. Years of tax history dissipate, and the audit letter arrives, and you realize you just detonated a financial nuclear bomb under your own feet. Mistake number 3, committing to what amounts to fraud on the state. Now, states take false filings very seriously. You can't just throw stuff at the wall and see what sticks. I mention that because I've seen some people do it. One of them is now in prison, who shall, of course, remain nameless. When you submit articles of conversion or the equivalent without the required underlying resolutions, plan of conversion, or attaining the proper approvals, you are certifying facts that are not true. We have a word for that. That's called perjury in many jurisdictions. In many states, that's not an oopsie. That can be a criminal act. Third-degree felony territory, for example, in Florida. And in Texas, it is a state jail felony. That's a permanent record that kills your future business opportunities, and prosecutors don't care that you didn't know. They see a fraudulent instrument filed with a government agency. Your company can be administratively dissolved while you are fighting the charges, and the family visits you through the glass. If that sounds like an extreme case, again, I invite you to do your own homework. This is all because you thought you could wing the paperwork. Don't do that. Mistake number 4, trapping your company in permanent limbo. Now, DIY filings get rejected all the time. Wrong fee, wrong entity name, wrong form in many cases, missing exhibits, you name it. Now your company is a legal ghost. The old state still considers your jurisdiction to be that state and keeps sending you tax bills and other compliance requirements that are imposed upon the company, while the new state has no record. You can't open bank accounts, sign contracts, or defend lawsuits properly. Operations freeze, cash flow shuts down, and fixing it requires expensive corrective filings, if it can be fixed at all. And these filings often must occur in both states, and sometimes the window closes forever if you take the ostrich approach and just bury your head in the sand. I had somebody in my office earlier this week who did exactly that. You're paralyzed, bleeding money every month, watching competitors eat your lunch, while you beg the secretaries of state for mercy that they simply don't have. Mistake number 5, relying on generic online templates or AI output. Those $99 downloadable forms and ChatGPT, Gemini, Grok, and Claude will give you answers that are garbage. I mean, really horrible stuff. They leave out entire categories of required documents, use outdated language or filing costs or addresses, or flat out invent procedures that don't exist. If I had $1 for every time somebody walked into my office with an extract from their conversation with Grok or Gemini and said, oh, here, just do this, I would be retired by now and I would not be making this video for you. But thankfully, I'm still here. And you're still listening, so that counts for something. In any event, when you take this DIY approach, you file confidently thinking you're covered. Guess what? You're not. Years later, particularly during a sale, audit, or lawsuit, the defects surface, and by then it's just too late to clean up. The transaction is often void ab initio. That's lawyer speak from the get-go. Cleanup attorneys quote 5- and 6-figure retainers just to assess whether anything can be salvaged. A lot of the time, the answer is no. Your business is dead on arrival, and you are on the hook for the mess. Mistake number 6, choosing the wrong structural path. That is to say, choosing foreign qualification or statutory merger instead of true redomestication. Amateurs consistently pick the wrong tool. Did you register as a foreign entity? Now you're paying annual fees and taxes in 2 or more states. Did you choose a merger? You've just invited unnecessary complexity, fees, and IRS scrutiny that flags you for audit, not to mention audit by the state taxing authorities. Only proper redomestication by statutory conversion severs the old state jurisdiction while preserving that ever important continuity. Choose wrong on your own and you voluntarily change yourself to what could amount to double taxation and compliance hell with no realistic opportunity for exit. Mistake number 7, forgetting to formally convert the entity out of the original state. This is a big one. You celebrate filing in the new state thinking you're free, but you never file the required statement or certificate of conversion back home. I see this all the time. The old state continues taxing you, sending you deficiency notices, and placing liens on your assets. Years of back taxes accumulate quietly. One day you try to sell the business or get a loan, and the liens block everything. Surprise, you still owe tens or in some cases hundreds of thousands of dollars to a state you thought you left behind when in fact you really didn't. Mistake number 8, breaking continuity of contracts, credit history, and entity names. Sloppy paperwork disrupts the legal chain of custody or title, to use a metaphor. Banks treat you as a brand new entity, requiring you to close old accounts, and they demand new applications and reset credit lines to zero. Vendors rewrite contracts from scratch. If that exact name for your business is not available in the new state, you may be forced into a rebrand that tanks your search engine optimization and business name recognition. Everything you spent years, if not decades, building evaporates because you missed subtle continuity clauses only knowledgeable attorneys know to include. Mistake number 9, piercing your own corporate veil, which, by the way, that can also apply to LLCs through inadequate formalities. This is another landmine. Incomplete records and missing internal approvals signal to courts that you never treated the entity seriously and instead treated it as your personal piggy bank. When the inevitable lawsuit arrives, judges are far more likely to disregard the LLC or corporate form entirely, meaning that plaintiffs sue you, yes, you personally. Judgments can attach to your home, your investments, your children's inheritance, your boat, your Tesla. If you drive a Tesla, no judgment, whatever. Bankruptcy often becomes the only escape. You didn't just lose the business, you lost everything. And mistake number 10, wildly underestimating the cost of cleanup when it all comes home to roost. You tell yourself, well, if something goes wrong, I'll just hire a lawyer later. Reality. I routinely charge clients $50,000 to $100,000 or more in legal fees, not to mention back taxes, penalties, interest, and lost opportunities that are incurred when I am brought in to clean things up after the fact. Many disasters are irreversible. The entity has already been dissolved. The tax event is already deemed to have taken place, and the civil and, in extreme cases, criminal exposure is already extant. The few bucks you thought you saved becomes the most expensive decision of your life. Now, these 10 mistakes are not theoretical. They happen every week to real business owners who were absolutely certain they, quote unquote, knew the law and could handle it themselves. Don't let that ego and overconfidence destroy you. You are a professional in your particular domain. Why would you not want to hire a professional to handle this intricate and nuanced multi-state legal transaction? Hire an experienced redomestication attorney before you file a single page. Your business, your wealth, your freedom, and your peace of mind are certainly worth it. Again, my name is Chad Cummings, and I hope you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this important information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for us to speak. I look forward to the opportunity to chat with and perhaps even work with you very soon.